Hey guys, this is Scott Horne, and in this video we're going to take a moment and talk about defaults that can occur in a seller finance transaction. Now, we're going to talk about defaulting as an investor buying a home with seller financing versus selling a home to a home buyer with owner financing as well. So if you find this video helpful, don't forget to take a moment and like it. If you have any comments, take a moment and comment below. And don't forget to subscribe to our YouTube channel as well. So let's just kind of jump right into defaults. So first off, if we're the investor who is buying a home from a seller and a default occurs, and guys, bad things happen to good people all the time and good intentions, I get it. If that happens, one of the things I always like to suggest is make certain your seller has a traditional mechanism to regain the property should they wish to do so. That traditional mechanism is foreclosure. Now, if a situation arises where you can no longer sustain the property, instead of going through a foreclosure, creating the issues, take a minute, reach out, talk with the seller about it, go through the situation. Maybe you can simply deed it back to them. You can't just deed a property back to somebody and go down and record it in deed records because they have to accept it. It wouldn't be valid in that situation. And communication goes so long in those scenarios to help everybody out. And oftentimes I tell sellers this up front when I'm buying the home from them, typically subject to the existing debt or with seller financing of some type. And so find the better way to solve that problem. Don't put yourself in a position where you buy a property where the seller has no traditional recourse and now you just bought yourself a lawsuit. Because you got in a bad situation, you pocketed money, this happened, that happened, whatever it might be, you can't make those payments, and the seller can't regain the home with filing a suit. Because as soon as that lawsuit is filed, guys, you're writing a check to some lawyer to get you out of it. And so always try to find the best solution in those scenarios and understand these things can happen along the way and make sure that you're okay. Typically, if you've done your transaction right, if your deal was structured right, which means you need to make sure you read those documents you're signing at least one time and know what the default is. Different deeds of trust can be written differently. For instance, when we do a closing, I like to protect our investors so the seller has the right to foreclose, but not to seek attorney's fees or deficiency fees or things of that nature against the investor along the way. Now that could change, but usually it doesn't. So make sure you know what your documents say, control what those read to whomever the drafting entity is going to be so that it says what you want it to say. Now, let's talk for a minute about a wraparound mortgage or a seller finance mortgage to a back-end home buyer or investor. And let's take the easiest one first, and that is an investor. So you've done a seller finance transaction to an investor. That investor has now signed a new note and a new deed of trust with you so that you're protected and they're making payments of X amount of dollars. You need to make sure you understand the foreclosure rules of your state. And typically they are different for a non-owner occupied person and an owner occupied person along the way. And so you want to check those kind of things out with a knowledgeable real estate attorney in your state. Now, here in Texas, where we're dealing with a non-owner occupied, our deeds of trust typically waive all types of notices to the investor, meaning you don't have a requirement in many cases to give that investor notice of default. Sometimes it's nice to give them a 10-day notice, but unlike a seller finance deal to an owner occupant where you have a minimum of 20-day notice, not always required, but read your paperwork and see what it says. Typically, it refers back to the property code then in effect at the time of default. So that's pretty easy to find out what that is. So foreclosing on an investor, keep in mind this isn't their homestead. I treat it that this is business, it's not a home. And although I use a fair but firm status, I'm a little bit more firm with investors who default because it's a business situation. And I'm going to be moving extremely quickly in those scenarios. And so you may have the ability to immediately accelerate the loan. Here in Texas, you can do that very quickly and foreclose in as little as 21 days. It's awesome living in Texas, guys, for that purpose. Other states, it may take 6 months. My gosh, there are some out there, it might take a year or longer, but most are going to be fairly reasonable along the way. Read your documents, know what your rules and regulations are in your state so you know how to navigate that transaction in the event that investor defaults. Then, if there is a default, I like to negotiate everything from a position of control. I am a total control freak. And if you're going to be in this business, you need to learn to be one too, because this is your money. If the investor is not paying you, most likely you're having to pay some type of an underlying debt on the property. So you want to move quickly so it doesn't pile up. And remember, this is your money, not somebody else's in most cases. So know what the rules are, what you can do, but then reach out to these people and communicate again. No one wants to be foreclosed on. I've asked that question a bazillion times. Does anybody want to be foreclosed on? And of course, no one raises their hand, obviously. And so giving somebody a reasonable exit strategy can be very beneficial. You can do that typically through what's called a deed in lieu of foreclosure in almost all states that are out there, and it works awesome. But if you're going to do a deed in lieu of foreclosure, make darn certain you check title first. You've got to make certain there aren't any judgment liens out there, child support liens, IRS liens, things of this nature that would have attached to the property after your investor bought it that could affect you, because if you take a deed in lieu, those judgment liens are going to follow the property and you just bought all of them. So be wise before you just automatically take back a deed in lieu and check title. So let's flip over to the flip side and talk about a owner-occupant for a minute who defaults. Now, just like with an investor at defaults, when a buyer owner-occupant defaults, your note is going to control the transaction as well as your deed of trust. Your note is going to set forth things such as late charges. Every finance code in every state's a little bit differently. For instance, in Texas, we can charge up to a 5% fee based on the principal and or interest payments both. I cannot charge a late charge on taxes and insurance because that's not my money. So make sure you know how to calculate that late charge appropriately. Read your note to understand what it says. Then make sure you've read that deed of trust, just like with the non-owner occupant scenario. Now, most states treat owner occupants very different than they do investors and non-owner occupant people. Remember, this is not a business purpose loan, it's a homestead. And so consumer protection issues are going to kick in left and right on us. And everybody's foreclosure rules are different based upon the state that you're in. Here in Texas, if there is a default on a non-owner occupant, again, read your deed of trust. Our typical deed of trust in Texas says that you follow your default notices as per the property code then in effect. In Texas, that means you have to give them a minimum of a 20-day notice unless your deed of trust gives them a longer term notice. It's never going to be shorter than that, but it could be longer. And in fact, most Fannie Mae and FHA type mortgages give a requirement of a 30-day notice to an owner occupant, not a 20-day notice. So you've got to follow your contract, which is your deed of trust, appropriately. So as I keep saying again, read your contracts, your note, your deed of trust, etc., so you know exactly what you can and cannot do along the way. Assuming your borrower goes in default, I always like to suggest to the investor, act quickly. Don't wait 30, 60, 90 days for you to do something. Don't think that your loan servicer is going to act quickly either. Loan servicers are not collection agents. They're not lawyers. They're there to collect a monthly payment and disseminate it appropriately based upon the paperwork. Yes, a loan servicer will send out a late notice in the event that there is a default. A loan servicer may make a phone call, but does that mean they're going to call every day? Nope. Are they going to send out multiple notices? Nope. I always tell investors to be wise because, again, this is your money going down the tubes rapidly if you don't stay on top of things. Don't let the servicer be your collection agent. Be your own collection agent. Watch your money flow. Know what's going on. Pick up the phone and call your borrower. You have the right to do it. Find out what's going on. Maybe you can work a deal out with them, and we'll talk about that in a moment. If not, negotiate from a position of control again, meaning if you've got to send certain notices, get those out the door first. I typically like to tell an investor that if a payment is due on the 1st, let's assume that it's late after the 10th, and that borrower hasn't paid by the 15th, you should be making a phone call. Know what's going on. Don't just send a late notice. That's going to go in that round file, in their office somewhere along the way. Call them, try to talk to them. Now, if they're non-responsive, typically by 10 days after the grace period expired, in my offices, we're shooting out an initial 20-day notice to cure the default. Now, when they get that certified mail letter from a lawyer, not from a loan servicer, but from a law firm, they're going to go, yikes, this might be serious. Now you can start some real communication quickly, hopefully. Now, by the way, one thing I have learned in this business is you cannot prevent what I call the idiot factor, where people just ignore everything. They go hide their head in the sand, and they think something's going to save them from, ruin and foreclosure. And at the end of the day, of course, it doesn't. So there's going to be a certain percentage of those people out there, no matter where you are and what you do. But for the most part, people don't want to get in foreclosure. People are looking for an exit strategy. I go back to the COVID era, which really had me worried because we held hundreds and hundreds of mortgages in portfolio. Now, during this time, believe it or not, we only had 4 borrowers who got into any type of default for more than just, a few weeks maybe. The good thing was each one of them took time and reached out to us. They told us their situation. In fact, all 4 were restaurant owners. Obviously, everything dried up until things got a little bit easier. And then they found other ways to start making money and do it. We let them go for 3, 4, 5 months, I believe. And then they started making payments. Sometimes they'd pay the entire payment. Sometimes they would pay a partial payment. And of course, I was looking at covering my debt with the income coming in along the way. But by helping them and working with them appropriately and giving that opportunity, every single one of them eventually brought their loans fully current. In some cases, it took a year. I think in one case, it may have taken a year and a half or so, but they made the effort and they did it, and they were appreciative that we had the ability to do that with them. Now, by the way, guys, not everybody has the financial horsepower to do that. I get it. And sometimes it is what it is. And if that is your situation, share that with your borrower. So often when a borrower gets in default, it's always somebody else's fault, not theirs. It's your fault for selling the property. It's your fault for having too high of a payment. It's your fault that they lost their job. It's your fault that they got divorced. It's your fault that they got sick. You name it, it's your fault. Never the case. Don't fall for that victim mentality. And again, use that fair but firm approach with them and lay the law down as to how it is. And you can do that in a nice way that works for everybody. And hopefully these things get worked out amenably. The first thing I tell every investor is read your paperwork, know what the rules and regulations are in your state. If a default occurs, don't sit on your thumbs, act quickly. Send out a late notice maybe, but make that phone call. And if you've got some various notice requirements, get those going quickly so you don't hinder yourself in the foreclosure process. You can always stop the foreclosure process, whether it's in the notice period or after the acceleration period. So briefly, the way a foreclosure works is if there's a requirement to give a borrower a notice to cure, you provide that to them. As I said here in Texas, it's a minimum of 20 days. At the expiration of those 20 days, we can then accelerate the mortgage, meaning now all principal and interest is due, that is outstanding, due, and owing. And by the way, hear what I said, all principal and interest. I did not say escrow. Principal, interest, tax, and insurance is what helps you reinstate that loan to bring the loan current. But in a default, what we as a lender are allowed to collect is all the principal we have due, any unpaid interest that is due, and any other fees such as legal fees, trustee fees, inspection fees, things of this nature that are directly related to the loan. We cannot go back and collect escrow, as that's not our money unless we wind up owning the house somewhere down the line. Understanding what the rules and regulations in your state are all important. What can and cannot you charge the borrower? And these things have got to be reasonable, so make sure you know what it is. I see so many investors that put unreasonable items in their mortgages sometimes. And when I see that, it's pretty obvious that a lawyer didn't draft it, or they didn't consult with a lawyer about that along the way. Follow the rules strictly, because you don't want to get into a wrongful foreclosure lawsuit if you don't follow those rules. Know exactly what you can do and do it right. If it says send the notice out by certified and regular mail, send it by regular and certified mail. Keep copies of everything to demonstrate you followed things correctly. But move quickly, because time is money in our business. So if there's a notice and cure period, once that is run, if you accelerate the loan, again, negotiate from a position of control where you have the right to either reinstate the loan form or not. Once that loan has been accelerated, you don't have a right to reinstate it unless your paperwork says it. And guys, most notes and deeds of trust do not give a borrower the right to reinstate. It becomes an option to reinstate. But again, check with a knowledgeable attorney in your state to know exactly what those are to help you navigate your mortgage properly and correctly. After the acceleration has occurred, your borrower is still unwilling to communicate. They're unwilling or unable to convey a deed over to you. And what I mean by that is this. Let's assume for a minute you're in an acceleration situation with a borrower. Maybe it's a husband and wife, and they're separated. Maybe the wife wants to execute a deed in lieu, the husband doesn't. I run into that quite a bit, unfortunately. You can't just take half the house back, guys. You got to take it all back. Maybe you find credit issues that are out there, judgment liens, IRS liens, things of this nature that cannot be removed from the property, and it's going to force you to foreclose, unfortunately. Know what those are so you can properly communicate that to your borrower. And the whole goal with this communication thing I keep talking about is to help you navigate regaining that property back quicker. The last thing we want to do is go through a lengthy foreclosure process if we don't have to. We don't want to drag that out. Thank goodness here in Texas, things move pretty quickly, actually in as little as 43 days. Other states, such as, let's say, Arizona, 6 months. Some states longer, and some in between all of those. Our goal is to navigate this to our benefit as fast as possible. Sometimes giving your borrower cash for keys works as well, because if I can get my house back faster than, let's say, 6 months, and I can get it back in 30 days by giving them 1 month rent back to them or something like this, awesome. You just saved yourself a ton of money if that borrower is not going to pay you anything. I like to talk to the borrower about the consequences of a foreclosure. Oftentimes they don't understand this. They also don't understand the consequences of bankruptcy, because they'll throw that out at you saying things like, well, I'm just going to file bankruptcy. So when I hear these things, I go, guys, do you really know how serious a bankruptcy is and how negatively that will affect your credit? Not just today and tomorrow, but for years to come. In a bankruptcy, it's a minimum of 3 years. Now, in Texas, at least a foreclosure is going to affect you for at least 7 years, if not longer. And all this combined, if they do both, it's going to be the same thing. And if a borrower does file bankruptcy, again, knowing how to communicate to them about that is so important. Just because you file bankruptcy doesn't mean you can live for free, because you are going to have a requirement to not only pay your trustee fee, which is an added increase, they're going to make you pay any and all of the other debt that you have out there as well. They're going to make you pay your mortgage starting within 60 days as well. And for all of those arrears that you owe, they're going to make you pay those off in a 4 or 5 or maybe a 6-year note as well to the borrower. It's not a free ride unless they file a Chapter 7 liquidation, and that's going to get you the house back pretty quick in those scenarios. So talking to a bankruptcy attorney, understanding how a non-owner occupied transaction works in bankruptcy and how a owner-occupied property works in bankruptcy, very important to understand that, as well as the difference between a Chapter 13, which is reorganization, and a Chapter 7, which is liquidation. You need to know those things to know how to better handle anytime a situation like this should occur. And it helps you navigate your deal better. It helps you have that conversation with your borrower. Most borrowers, they don't want to get foreclosed on. They don't want to find bankruptcy. They're looking for a solution. So could a solution be something as simple as a loan modification? Maybe. And guys, I have worked out many hundreds and hundreds and hundreds of deals with borrowers to everybody's benefit. We get paid, maybe we get paid a little bit of extra interest or something. The loan is caught up. I didn't have a default. I didn't go pay lawyers for foreclosure or bankruptcy and things like that. And eventually I got all my money. Now, I had to be able to maintain that loan too. So remember, always, being a hard ass isn't always the best thing to do. And the borrower comes out ahead of the game as well. And they will appreciate these kind of things and maybe be a better borrower for you in the future. And so learning how to navigate the default process, how you talk to that borrower, what your rules and regulations are for your state's property code, bankruptcy, etc., is so important to know so you can open meaningful communication with your borrower and help them through the situations they're in. And guys, at the end of the day, sometimes it just is what it is, and you got to move forward with that foreclosure and look at how those things work. And so typically, after that cure period, whatever that might be, you've accelerated your loan and you're waiting for that day of foreclosure. Your trustee could be a lawyer. It could be yourself as a trustee if the state allows you to do that. You go down and they foreclose on the home, and you will provide your trustee with the amount of money you want them to open that bid with. Now remember, guys, when you're foreclosing on your borrower, you are only entitled to profit what you are owed. That is all of your principal, all of the unpaid interest, your direct fees, such as your trustee fees, legal fees, any collection fees, other reasonable fees allowed by your note and or deed of trust, such as maybe an inspection fee, things like this along the way. If the property sells for $50,000 more than your total payoff is, you don't get that money. That goes back to, first and foremost, usually any lien holders of record who are junior to you, and the rest goes to your borrower. So you don't get to do that. Now, at the auction, can you be the successful bidder as a lender? Absolutely. And sometimes you're bidding just the amount you owe and you win it and what that borrower owes you. Other times, there may be other bidders out there and you've got to bid a little bit more for the property, understanding you're going to be fully covered for all your fees out of all that money. But anything over and above what you're owed will go back to that borrower or lien holders of record who are junior to you in some format. But just learning how to walk through these scenarios, how to take a moment to be reasonable, not to have a knee-jerk reaction to these kind of things, open the communication, being swift and sure about how to work these deals out with your borrower, having some options available in that conversation with them, realizing that it's your money, your loan, things of that nature there, and maybe your credit as well. Not letting a third-party loan service or somebody do all this for you because they're never going to be as good as you are. Putting together the right team, track things properly, and I think you'll find that this will help you along the way in the event that there ever is a default on some type of a seller finance transaction. So guys, I hope you found this helpful and beneficial. If you did, take a minute and like it. Don't forget to comment below. We'll do our best to answer those for you. And if you like everything, guys, take a minute and join our YouTube channel as well. We'll look forward to seeing y'all next time.